I want you to take a look at the defendant's exhibit, page 3. It's the document that Judge Juarez was focusing on from this advocacy organization. And it says, you forfeit your security deposit. The landlord cannot charge you for anything else. However, you are still responsible for any past due rent or other charges assessed before you gave your notice to end the lease. If she gave you $1,000 for the security deposit and the past due rent, that would come to what?
As far as September rent?
Yeah.
You're saying I can't charge
well,
her?
I'm saying this is what it seems the law is in Minnesota under these particular circumstances. So you could only charge for September rent.
And no damage.
And that's it.
She forfeits her deposit, and meaning she...
Automatically, she's already given you the $1,000 security deposit, right?
Yeah.
You've used it.
Yeah.
And it seems to me that's what the law requires under the circumstances. And in a sense, it makes sense because she's under this kind of stress to move out and find another place. So she forfeits the security deposit, which theoretically would ordinarily cover any
if it was a normal
damage,
wear and tear.
As a matter of fact, you say it was $2,000 worth of damage?
It wasn't normal wear and tear. There's holes, there's things missing that she said that she would replace.
What were you experiencing at that time? You filled out this document which said that you had an order of protection. A qualified third party wrote a statement that you had to end the lease due to fear of violence. What was happening with you?
So the party was driving by our house. He was actually coming into my house while I was gone because you just need a code to get in the door. So my tires had been popped a few times. My windshield was broken. He was following my kids from the bus stop. My older son had to take the city bus, so he was like following him on the city bus. But there had been domestic violence before that, physical.
Now, why didn't you clean up the problem?
I just, honestly, I have 4 children, so it was a lot to get what I did have out of there and go as fast as I could.
You left as fast as you could without
delaying.
All right, well, thank you very much. I don't have any more questions. We're going to excuse now, and we will deliberate in your case. Thank you both very much.
This courtroom is now in recess.
Well, what we have here is a tenant who was clearly involved in a domestic violence situation that was substantiated by a third-party affidavit. So there's no question there, and the statute's pretty clear in Minnesota that a tenant can terminate or end their lease before it expires if they have an immediate fear of violence themselves or their loved ones, and we have that here. The notice that she provided to the defendant stated on September 25th said that she was going to be out September 30th, so she obviously should be responsible for September's rent. Question is she responsible for October's rent? Right. And the $770 cleaning services that the plaintiff says that it cost her to remove her items, is she responsible for that? Well, according to the statute, no.
Once she gave her the notice that she had to move out, I think she's responsible for past due rent, but I don't think that gap period is contemplated.
Yeah.
So you're thinking she would be liable for October?
Wouldn't.
Would not. Oh, I agree.
Would not.
I agree. I think the statute carves out a very clear exception that, unlike terminating tenancies for other reasons, pursuant to a lease or under the law, you can give notice in the same month and vacate. You can leave everything behind because there are situations where that is what you have to do in order to keep yourself safe.
I think we should award the late fee. That's obviously
I agree.
That was assessed.
I think that even though she did leave the premises in pretty bad condition.
It was bad.
I think the statute also contemplates that. It's the security deposit is forfeited, and it specifically prohibits the landlord from charging for fees beyond that. So I don't think, unfortunately, that she's entitled to the $770.
So the verdict is for the plaintiff in the amount of $1,390.
Agreed.
All right.